Welcome back, everyone. Ready to dive into something that impacts pretty much every aspect of our lives?
Intriguing. Lay it on me.
Well, today, we're tackling contract law. And before you tune out thinking it's all boring legal jargon,
Oh, I was about to say.
trust me, it's way more interesting than you might think.
Okay, you've got my attention. I'm always a bit skeptical when it comes to legal stuff. It feels like it's designed to be confusing, you know?
I hear you. But that's kind of what we're here to do. Demystify it, right? Break down the basics, bust some myths, maybe even tackle a few controversial clauses along the way.
All right, I'm game. Convince me.
So let's start with the big picture. We're talking contracts, those agreements that bind us, whether it's buying that morning coffee or closing a major business deal.
Okay, I get that. But where do we even begin? I mean, contract law seems like this massive, complicated system.
It is. But every complex system has its roots somewhere, right?
Yeah.
And for contract law, those roots actually stretch pretty far back to medieval England.
Medieval England. Knights and castles and contracts.
Exactly. I was reading about this system called the law merchant that was developed back then. Essentially, traders needed a way to ensure fairness and predictability in their dealings.
So, like a set of rules for the marketplace? Makes sense.
Exactly. It was like a DIY legal system born out of practical necessity. And you know what's amazing?
Prove that.
Over time, those basic principles from the law merchant were absorbed into English common law. And guess what?
Don't tell me. Our legal system is based on that, too.
You got it. So we're talking centuries of legal evolution, from handshake deals in medieval markets to the complex contracts we see today. Pretty cool, right?
I have to admit, that is a pretty cool origin story. All right, so we've got this historical context, but what about the core principles of contract law? Are they still the same after all this time?
They are. At its heart, a valid contract boils down to three key elements: offer, acceptance, and consideration. Kind of like the three-legged stool. You need all three legs for it to stand up in court.
Okay, I like that analogy. Simple and clear. But let's break it down further, starting with offer. What exactly makes an offer legally binding? Is it just me saying, hey, I'll sell you this?
Not quite. It's a bit more nuanced than that. An offer has to be clear, specific, and demonstrate a genuine intention to be bound by those terms.
So it can't be vague or ambiguous.
Oh, exactly. Think about it this way.
Yeah.
Could a reasonable person understand what they're agreeing to based on the offer alone?
Okay, so context matters.
Absolutely. And speaking of context, have you ever heard about the Pepsi Harrier jet case?
The what? Pepsi, Harrier Jet? Those two don't exactly go together.
Right. So there was this Pepsi commercial that aired during the Super Bowl, and it jokingly offered a Harrier jet as a prize. Well, someone actually tried to sue Pepsi, claiming they were entitled to the jet.
Oh, come on. They can't be serious.
It might sound crazy, but that case actually went to court. And it perfectly illustrates how judges determine whether an offer is valid. They focus on the objective meaning of the offer, not just what one party might have intended. Obviously, Pepsi didn't actually need to give away a multi-million-dollar fighter jet, right?
I'd hope not. That'd be one heck of a marketing budget.
Exactly. And no reasonable person watching that commercial would have thought it was a serious, legally binding offer. It was a marketing gimmick, plain and simple.
So, a Super Bowl ad for a fighter jet. Not a contract. Lesson learned. All right, I'm following so far. We've got this offer thing sorted out. What's next?
Acceptance. That's the second leg of our contract stool.
Acceptance. So that's when someone agrees to the terms of the offer. Seems straightforward enough.
In essence, yes. But there are different ways to accept, depending on the type of contract. In a bilateral contract, both parties make promises. Think about buying a house. You promise to pay a certain amount, and the seller promises to transfer ownership. Two promises, two sides bilateral.
Okay, that makes sense. But what about those situations where actions speak louder than words?
I like where you're going with this. Give me an example.
Like those lost dog reward posters. You don't call up and promise to find the dog, you just go out and do it.
Exactly. That's a perfect example of a unilateral contract. The acceptance happens through action, by fulfilling the terms of the offer. Finding and returning that lost pup, boom, you've accepted the contract.
Ah, I see. So it's not always about explicitly saying, yes, I agree. Sometimes it's about taking action.
You got it. Now, let's say we have our offer, we have our acceptance, everything seems clear. But what happens if the acceptance doesn't perfectly match the offer? What if there's even a slight discrepancy?
Ooh, that's where things could get messy, right?
Potentially. That's where the mirror image rule comes into play. In traditional contract law, your acceptance has to be a perfect reflection of the offer. Any changes, even minor ones, could be seen as a counteroffer, essentially restarting the negotiation.
So if I order a red widget online and they send me a blue one, can I just say, nope, not what I ordered, contract's broken?
In theory, yes, under strict common law. But don't worry, there are some safeguards in place. In the US, we have the Uniform Commercial Code, or UCC. It adds some flexibility, especially for business transactions.
So the UCC acknowledges that minor discrepancies happen in the real world and aims to prevent people from exploiting those tiny errors to back out of deals.
Exactly. It's about being reasonable and practical. So that blue widget might still be a valid contract, even if it wasn't the exact color you initially wanted.
Okay, good to know. So it's not always completely black and white. I like that. Now we've got the offer, we've got the acceptance two legs of our stool. What's the third leg again?
Consideration. That's the glue that holds the whole contract together. Think of it as the price of the promise, something of value that's exchanged between the parties.
Something of value. So it could be money, obviously.
Yep, money is a common form of consideration. But it can also be goods, services, or even a promise to do something. Or not do something, for that matter.
Okay, I'm starting to see the bigger picture here, but I'm curious about those situations where things get a bit fuzzy. Can you give me an example?
Sure. Let's say you hire a contractor to remodel your bathroom for, let's say, $5,000. Halfway through, they hit you with, oops, need another $1,000 to finish. Now, that demand for extra money might not actually be legally enforceable.
Wait, really? Why not?
Because the contractor was already obligated to do the job for the original price. They're not giving you anything new for that extra money, no additional consideration.
So they can't just jack up the price midway through for something they've already agreed to do.
Exactly. They're trying to get something for nothing, essentially.
Okay, I'm liking this consideration concept, but I'm guessing there are exceptions.
Always exceptions. If both sides agree to modify the contract, and there's a legitimate new benefit for each party, like the contractor agreeing to add some upgrades for that extra money, that could be valid consideration. It's all about balance, that give and take.
Makes sense. So it's not about being rigid, it's about making sure both sides are getting something of value throughout the process.
Absolutely. And this idea of consideration can get pretty interesting in those trickier cases. You mentioned earlier that you're a bit of a skeptic.
Yep, I like to question things, dig a little deeper, keeps things honest, right?
I respect that. Well, there's this fascinating case, Wood v. Lucy, Lady Duff Gordon, where the court had to get pretty creative to figure out if there was actually consideration involved. Have you heard of it?
Can't say I have. Give me the rundown.
All right, so picture this. Lady Duff Gordon, a super famous fashion designer, strikes a deal with this marketing guy named Wood. The contract was a bit vague on what Wood actually had to do to promote her designs. Lady Duff Gordon later tried to back out, claiming the whole thing was invalid because Wood wasn't really committing to anything. No consideration on his part, she argued.
Ah, so she was essentially saying he's getting something for nothing.
Exactly. But the court, in a pretty brilliant move, decided that the agreement implied that Wood had to use reasonable efforts to market her designs. They basically filled in the gaps to find that missing consideration.
Oh, so sometimes what's not explicitly stated in a contract can be just as important as what is written down. That's pretty mind-blowing.
It is, and it shows how contract law isn't always black and white. There's a lot of interpretation involved.
So we've got our three-legged stool, offer, acceptance, consideration. Seems pretty straightforward, at least in theory. But I have a feeling there's more to the story. Are there ever situations where a contract might not actually hold up in court, even if those elements seem to be in place?
You're reading my mind. That's exactly where we're headed next. We'll explore those situations, called contract defenses, where an agreement might not be as ironclad as it seems.
All right, bring on the defenses. I'm ready to see how this all plays out in the real world. So we've laid our foundation, right? We explored those crucial elements of a contract: offer, acceptance, and consideration.
It's like constructing a building. You've got to have that solid foundation before you can even think about putting up the walls.
A strong foundation is key, but even then, things can still go wrong, you know? Cracks can appear, and the whole thing could crumble.
Exactly. And that's where contract defenses come into play. These are those situations where a contract might not actually be enforceable, even if, at first glance, it looks like a perfectly valid agreement.
Okay, now you've got me intrigued. Give me an example. When might a contract be considered completely void?
A void contract is basically like it never even existed in the eyes of the law. Something essential is missing, Or maybe the whole purpose of the contract is illegal.
Like, let's say, a contract to rob a bank.
Precisely. A contract to commit a crime is void from the very beginning. The law is not going to help you enforce a contract to do something illegal.
Makes sense. The courts aren't exactly in the business of enabling criminal activity. All right, so we've got void contracts, but then you also mentioned voidable contracts. How are those different?
A voidable contract is actually valid until someone decides to challenge it.
Until someone says, hold on, something's not right here.
Exactly. And this often happens when one of the parties didn't actually have the legal capacity to enter into the agreement in the first place.
Interesting. Can you give me an example of when that might happen?
Well, one common scenario is when one of the parties is a minor.
Someone under the age of 18?
Exactly. They're not legally considered capable of making those kinds of binding agreements. So a contract with a minor would be voidable. The minor could later decide they want out, and the contract wouldn't be enforceable.
Okay, that makes sense. The law is there to protect those who might not fully understand the consequences of signing a contract. It's not just about age, though, right?
You're right. Mental incapacity can also be a factor. If someone isn't mentally competent, if they don't understand what they're agreeing to, that contract might also be voidable.
Gotcha. So it's about protecting people who might be vulnerable or taken advantage of. We've covered void contracts, voidable contracts, and then there's this third category, unenforceable contracts, right?
Yeah, I got it. Unenforceable contracts are a bit trickier. On the surface, they might seem valid, but there's something that prevents a court from actually enforcing them.
Something's off, but it's not immediately obvious. Okay, I'm curious. Give me an example.
One common scenario involves something called the statute of frauds. It's a rule that requires certain types of contracts to be in writing to be enforceable, like agreements for buying or selling land, contracts that can't be performed within a year. Those often fall under this rule.
So it's about having that paper trail, that clear evidence of what was agreed upon.
Exactly. It's about protecting people from relying on fuzzy memories or verbal agreements when it comes to these really important transactions.
Okay, so the message is clear. Get it in writing, especially for those big, life-changing deals. But let's say you do have a written contract, all signed, sealed, and delivered, and then a dispute arises. What happens if one party starts claiming there were verbal agreements that contradict what's written down in black and white?
That's where the parole evidence rule comes in. It's a rule that basically says what you see is what you get. It prevents someone from introducing evidence of those prior verbal agreements that contradict what's in the final written contract.
So no trying to rewrite history after the fact. What's on paper is what matters.
You got it. The written contract is king. Of course, there are always exceptions, right?
There always are. Lay 'em on me.
If there's clear evidence of fraud, duress, or if the language in the contract is so ambiguous that it's open to multiple interpretations, those could be valid reasons to challenge what's written. But in most cases, what's in that final signed document is what the court will rely on.
Okay, so the message is clear. Get everything in writing and make sure it's crystal clear what everyone's agreeing to. I'm starting to see how these contract defenses act as safeguards. They're there to protect people from being bound by agreements that are unfair, unclear, or made under pressure.
Exactly. It's about leveling the playing field and making sure contracts are tools for fairness, not weapons of exploitation. Now, I think it's time to shift gears a bit. We've talked about how contracts are formed, what can make them invalid, but what happens when those carefully crafted agreements, well, when they just fall apart?
You mean when someone breaks the contract? When a party doesn't hold up their end of the bargain, what are the consequences?
Precisely. Breach of contract. It's one of those legal terms that gets thrown around a lot, but what does it really mean in practice? What happens when a contract goes belly up? What recourse does someone have?
Good questions. And the answers can get pretty complex. But essentially, contract law has this whole toolbox of remedies to address those situations where agreements are broken. The main goal is always to compensate the injured party, the one who suffered because of the breach, for their losses.
So it's not about punishing the person who messed up. It's more about making things right for the person who was harmed.
Exactly. The focus is on trying to put the injured party back in the position they would have been in if the contract had been followed. It's like trying to rewind the clock, undo the wrong, and make it as if the breach never happened.
Okay, I like that. But how do courts actually go about figuring out what that compensation should be? I mean, how do you put a price tag on a broken promise?
Well, they use this principle called expectancy. They look at what the injured party reasonably expected to gain from the contract, and then they try to award them the financial equivalent of that lost opportunity. It's all about fulfilling those expectations that were created by the agreement.
Okay, let me try this out. Let's say I was all set to buy this super rare antique chair for $5,000, but the seller backs out at the last minute. Turns out they found someone else who's willing to pay $6,000 for that same chair. Would I be entitled to that extra $1,000?
You very likely would be. You expected to get that chair for $5,000, and now, because the seller broke the contract, you have to pay $6,000 to get a similar one. The court would want to make up for that difference, to put you back in the financial position you would have been in if the original contract had been honored.
Gotcha. So it's not about me getting a windfall. It's about restoring what I lost because of the breach. But what if the breach isn't about tangible goods? What if it's about services? Like, I hire a contractor to build an addition on my house, and they just walk off the job.
Ugh. Construction contracts. They can get pretty complicated when it comes to calculating damages. A lot depends on the timing of the breach. If the builder bails right at the beginning, before they've even started, it's relatively straightforward. The homeowner finds a new builder, and the damages would be the difference between what they were going to pay the original builder and what they end up paying the new one.
Okay, that makes sense. But what if they've already started building, maybe they've laid the foundation and then they walk off the job?
That's where things get more complex. The homeowner still needs to find someone else to finish the work, but the original builder might actually be entitled to some compensation for the work they already completed. It's called restitution.
Wait, hold on. The person who broke the contract could actually get paid. That doesn't seem very fair.
It might seem counterintuitive, but restitution is about fairness too. It allows a party to recover the value of what they contributed, even if they didn't ultimately fulfill their end of the bargain. You can't just let someone get away with benefiting from another person's work without paying for it.
Okay, I see. So even in a breach, contract law tries to be fair to both sides, considering all the circumstances.
Precisely. It's not a simple winner-takes-all situation. It's about finding a just and equitable outcome.
All right, we've talked about expectancy and restitution as remedies. But are there other types of damages that courts might award in these breach of contract cases?
Definitely. There are several categories. Compensatory damages are probably the most common. These cover those direct foreseeable losses that were caused by the breach, like that extra $1,000 you'd have to pay for the antique chair in our earlier example. And then there are consequential damages.
Okay, break that down for me. How are consequential damages different?
Think of them as the ripple effect of a breach. They're for those losses that flow indirectly from the breach. So let's say because the seller backed out on that chair deal, you couldn't furnish your new apartment on time and had to stay in a hotel for a few weeks. Those hotel costs, those could be considered consequential damages. They wouldn't have happened if the original contract hadn't been broken.
So it's not just about that initial financial hit. It's about the broader consequences that a breach can trigger. Makes sense. But are there any limits to how much someone can claim in these consequential damages? Can I just say, hey, because of that broken contract, I missed out on $1 million business deal?
There are definitely limitations. The damages have to be directly caused by the breach. You have to be able to prove them with evidence, and they have to have been foreseeable at the time the contract was made. The other party can't be held liable for something they couldn't have reasonably predicted.
No blaming a broken contract for missing out on winning the lottery then.
Exactly. It's about holding people accountable for the natural consequences of their actions, not for some wild, unpredictable outcome. Now, there's one more super important concept related to all this talk about damages: mitigation. The injured party can't just sit back and watch those damages pile up. They have a duty to try to minimize their losses.
So going back to that construction example, if the builder walks off the job, I can't just wait a whole year to hire someone new and then demand to be compensated for all that lost time.
Nope, you'd be expected to act reasonably. Find a new builder as quickly as possible to keep the project moving forward. Contract law encourages everyone to be responsible and to take steps to minimize the harm. It's about finding practical solutions, not about creating opportunities for one party to take advantage of the situation.
Okay, so it's a two-way street. Both sides have a responsibility to act in good faith, even when things go wrong. I'm really seeing how contract law tries to strike that balance between holding people to their agreements and making sure there's fairness throughout the process. We've focused a lot on money as a remedy, but I remember our sources also mentioned equitable remedies. What are those all about?
Equitable remedies come into play when simply getting money back isn't enough to fix the situation. They're basically court orders that tell a party to do something or to stop doing something. They're used when financial compensation just wouldn't truly address the harm that was caused.
So it's about more than just the dollars and cents. It's about enforcing the spirit of the agreement, making sure the intent of the contract is upheld.
Exactly. The two most common types of equitable remedies are specific performance and injunctions. Specific performance means the court actually forces a party to fulfill their contractual obligation. Imagine you have a contract to buy a one-of-a-kind vintage car, and the seller tries to back out. Money might not be enough to make you whole because you can't just find another identical car, so the court might order the seller to hand over that unique car as they originally agreed.
So the court steps in and says, nope, you made a promise, and now you have to keep it. I like that. It's about more than just money. It's about upholding that commitment. But I'm guessing specific performance isn't used very often, right?
You're right. It's usually reserved for those situations where the subject of the contract is truly unique, something irreplaceable. Now, an injunction is a bit different. It's a court order that tells someone to stop doing something.
So it's like a cease and desist order.
Exactly. Let's say a company is contractually obligated to keep certain trade secrets confidential, but then they start spilling the beans to a competitor. The court could issue an injunction to stop them from sharing any more of those confidential secrets.
So it's a way to prevent further damage when money alone wouldn't solve the problem. It's like putting a legal stop sign in front of harmful actions.
You've got it. And just like with specific performance, injunctions are usually used when the subject matter of the contract is something special, something that can't easily be replaced or remedied with money. It's about protecting those intangible values that contracts are often built upon.
I'm really starting to appreciate how contract law has all these different tools and mechanisms to handle such a wide variety of situations, from those straightforward financial disputes to these more complex cases where it's about making sure promises are kept, secrets are protected, and fairness prevails. Now, while we're on the topic of remedies, there's one more term I wanted to touch on. Liquidated damages. What are those all about?
Liquidated damages are a clever way to simplify things ahead of time if a breach occurs. It's when the parties to a contract agree in advance on what the damages will be if one of them breaks the agreement.
So it's like predetermining the penalty, right? Taking the guesswork out of it.
You could think of it that way. It helps to avoid those messy courtroom battles over proving damages after a breach has already happened. But of course, courts are careful about these clauses. They want to make sure those liquidated damages are a genuine pre-estimate of the potential losses, not some sort of excessive punishment.
Okay, so you can't just throw in some ridiculously high number to scare the other party into compliance.
Exactly. It has to be reasonable, justifiable, a realistic estimate of the actual harm the breach would likely cause. It's about making the injured party whole, not about punishing the other side.
Makes sense. Now, while we're on the topic of money, I've got a question that's been bugging me. What about the legal costs that can come with enforcing a contract? You know, attorney fees, court costs, all that. If I win a breach of contract case, should the other side have to pay my legal bills?
Attorney fees. It's a tricky area. Generally speaking, each party is responsible for paying their own lawyer, win or lose.
Really? Even if I'm the one who was wronged? That doesn't seem fair.
It can be frustrating, I know. But there are exceptions. Some contracts include clauses that specifically say the winning party can recover their attorney fees. And in some types of cases, like consumer protection lawsuits, the court might decide to award attorney fees to the winning side. There's definitely something to be aware of when you're negotiating a contract. Knowing who's on the hook for those legal costs can be really important.
Okay, I'll definitely be keeping an eye out for that in the fine print. Now, one last thing I wanted to touch on. Our sources mention punitive damages, which sounds pretty intense. What are those all about?
Punitive damages are designed to do exactly what the name suggests, punish. They go beyond simply compensating the victim. They're meant to deter others from engaging in similar bad behavior.
Interesting. Are those common in breach of contract cases?
Not really. The main focus in contract law is usually on making things right, on restoring the injured party to the position they would have been in. Punitive damages are more common in those tort cases, cases that involve some kind of intentional harm or recklessness. Think of things like fraud, defamation, assault. Those types of actions that really go beyond just breaking an agreement.
So if someone intentionally breaks the contract, and they're doing it just to cause harm, just to be malicious, That might be a situation where punitive damages could come into play.
It's possible, but it would have to be a pretty egregious situation where the breaching party's actions are clearly malicious and go beyond a simple breach of contract.
Okay, so it's not about punishing every little mistake or oversight. It's about deterring those really bad actors who were intentionally trying to cause harm.
Exactly. Contract law recognizes that sometimes breaches happen. Things don't always go according to plan. It's not about assuming bad intentions every time a contract goes sour. It's about finding a fair and just resolution that takes all the specifics of each situation into account.
This deep dive into breach of contract has been eye-opening. I had no idea there were so many nuances, so many different types of remedies, all these considerations that go into making things right when a contract falls apart. It's like a whole legal ecosystem designed to handle the complexities of agreements gone wrong.
It is a complex area for sure. But even having a basic understanding of these concepts can help you navigate contracts with more confidence and protect your interests. It's about knowing your rights, understanding those potential risks, and being prepared to handle those inevitable bumps in the road.
I agree. Knowledge is power, and I definitely feel more empowered to approach contracts with a clearer understanding of what's really binding and what happens when things go sideways.
That's what we're here for. And speaking of complexities, we've really only scratched the surface. In the final part of our deep dive, we'll explore some even more intriguing concepts like third-party beneficiaries, assignment, delegation, even those international twists that can make contract law even more fascinating. Stay tuned.
We've covered a lot of ground in this deep dive, haven't we? From those medieval roots of contract law to the nitty-gritty details of what happens when things go wrong.
It's been quite a journey. And I have to say, one thing that's really stood out to me is how contract law tries to strike this balance, this delicate balance between enforcing those agreements and making sure things stay fair and just along the way.
I totally agree. It's not just about mindlessly applying these rigid rules, right? It's about looking at the whole picture, the context, what the parties intended, all those real-world complexities. That's what makes this so fascinating.
Absolutely. And speaking of real-world complexities, one thing that can get pretty tricky, it's when contract law starts to impact people who weren't even directly involved in that original agreement.
Ah, yes. Those third-party beneficiaries we touched on earlier. It's a concept that can really trip people up.
Yeah, for sure. It's the idea that someone who's not a party to the contract, they didn't sign anything, but they might still have some rights under it. It's like, imagine a life insurance policy. You take out a policy on yourself, right? And you name your child as the beneficiary.
Okay, so the child, even though they didn't sign that contract with the insurance company,
they still have enforceable rights under it. If something happens to you, well, they've got the right to collect that death benefit.
it's like those rights are transferred to them, even though they weren't part of the original deal. Pretty interesting. But I imagine there are rules about who can be a third-party beneficiary, right?
Oh, absolutely. There are different types of third-party beneficiaries, and the law gets very specific about who actually has those enforceable rights. One of the sources we looked at, Contract Law for Dummies, it points out this key distinction. You've got intended beneficiaries, and then you've got incidental beneficiaries.
Okay, break that down for me.
Intended beneficiaries are those who the parties to the contract, they specifically wanted to benefit from that agreement. Like that child in our life insurance example, that was the whole point, right? But then you have incidental beneficiaries, folks who might end up benefiting in some way.
But it wasn't the primary purpose of the agreement.
Right. They might get some sort of indirect benefit, but it wasn't intentional. And those folks, they don't have the same legal standing as an intended beneficiary.
Gotcha. So there's a clear line drawn between those who are deliberately included in the contract's benefits and those who might just happen to benefit sort of by accident. Makes sense. Now, what about those situations where the parties to a contract, what if they want to transfer those rights or obligations to someone else?
Ah, you're talking about assignment and delegation. They're all about shifting those contractual rights and duties around.
Yeah, our sources mention those terms, but I'd love you to unpack them a bit more.
Okay, so assignment is basically like transferring that right to receive payment under a contract. Say you did some work for a client and they owe you $1,000.
Okay, I've been there.
You could actually assign that right to get that money to someone else, maybe to pay off a debt you owe them.
So instead of the client paying me directly, they'd now pay that third party.
Exactly. You become the assignor, the one giving up the right, and whoever you're giving it to, they're the assignee. Pretty straightforward. Now, delegation, on the other hand, that's about transferring duties, not rights. Let's say you hire a contractor to remodel your kitchen.
Okay, I'm with you.
And that contractor turns around and delegates the cabinet installation to a subcontractor.
So the subcontractor is the one actually doing the work now. But if something goes wrong with those cabinets, who's ultimately responsible? The subcontractor or that original contractor I hired?
That's the million-dollar question, right? And here's the thing. Even though that subcontractor is doing the work, that original contractor, they're still on the hook if the job isn't done right. Delegation doesn't completely let the original party off the hook. They're still accountable to you, the one who hired them, for making sure that contract gets fulfilled.
So it's like a chain of responsibility. Just because you delegate a task doesn't mean you break that chain. Interesting. Now, you mentioned assignment and delegation as ways to shift those rights and duties around. But is it possible to completely transfer everything, rights, duties, the whole shebang, to a brand new party? Like hit the reset button and have a whole new contract with a different player?
That's where novation comes in. Novation, it's this three-way agreement. A new party steps in, takes over all the rights and obligations of one of the original parties, and it completely releases that original party from the contract.
Gotcha. So it's not just one party transferring something to another. All three parties involved have to agree to make that switch happen. It's like a contractual baton handoff, but everyone has to be on board with who's getting that baton.
That's a great way to put it. Now, before we wrap things up, I want to touch on one more concept our sources brought up: tortious interference.
Ooh, that sounds a bit dramatic. What's that all about?
It does sound dramatic, right? But basically, it's when someone intentionally messes with a contract between two other parties. They interfere in a way that causes one of those parties to break the agreement. So imagine you have a contract with a supplier. Everything's going smoothly. But then a competitor swoops in and somehow convinces that supplier to break your contract and start working with them instead.
Okay, so it's about protecting those existing contracts from outside forces that might try to disrupt them. But I imagine there are limits, right? Like, what if that competitor simply offered the supplier a better deal? Is that considered interference?
It can be tricky, but true of tortious interference, you usually have to show that the interference was wrongful or unjustified in some way. Simply offering a better deal. That might be considered fair competition, part of the game. But if that competitor used threats, lies, sabotage, those underhanded tactics to pressure the supplier to break that contract, that's when it crosses the line.
So it's not about preventing competition. It's about making sure everyone plays by the rules.
Exactly. No dirty tricks allowed. Wow, I have to say, this whole deep dive into contract law has been truly eye-opening. I never realized how much complexity and nuance there is to these agreements that we encounter pretty much every single day.
I'm right there with you. It's like this whole hidden world that governs so much of our lives, from buying groceries to negotiating business deals.
It really is. And for our listeners out there, I think the big takeaway is that contract law might seem intimidating, maybe even a bit boring at first glance, but it's ultimately a tool.
A tool for what?
A tool for building trust, for ensuring fairness, and for making sure those promises are kept. So approach those contracts with knowledge, with confidence, and with a healthy dose of curiosity. You might be surprised at what you discover.
Great advice. And with that, we've come to the end of our deep dive into contract law. It's been an absolute pleasure exploring this fascinating world with you and with our amazing listeners, of course.
The pleasure was all mine. Until next time, everyone, happy contracting.